Okay, the Akira versus Brenay lawsuit is over. The verdict is in, the judgment was entered, and we'll probably see collection efforts begin within the next few months. But I feel like we are in what I like to call the eye of the hurricane, because there are some criminal proceedings behind it, there are some other things happening in January, and then that is when the alienation of affection lawsuit between Devin and Tim begins. So before that lawsuit hits the courtroom, you're going to hear alienation of affection tossed around the internet with lots of assumptions and opinions. So I think this is a great time for a crash course. What it is, where it came from, why it still exists, and lastly, the most important part, what it actually punishes, because I feel like that's where a lot of people on this internet are getting it wrong. So let us begin. What is alienation of affection in North Carolina? And yes, I'm saying North Carolina on purpose. Although 6 states recognize this tort, I think it was 7 or 8 at some point, but I don't find any evidence that shows that Illinois and the other state I don't remember at this moment actually recognize that tort anymore. I digress. Even though there are 6 states that recognize their tort, their definitions and standards may not be identical, so we're talking strictly NC. A quick definition, a tort is a civil wrong. It is part of civil law, not criminal law. When you sue someone for a tort, you're asking for damages, not for criminal punishment. So no one's going to jail for alienation of affection. It is not a criminal offense. Think of North Carolina as having 2 heart bomb torts, and I say heart bomb as in meant to soothe heartbreak. Alienation of affection, which is about the relationship, and then criminal conversation, which is about sex. This distinction will be important for later. NC General Statute 52-13 is what sets the guardrails. You can only complain about conduct that happened before the spouses permanently separate. You have 3 years from the last wrongful act to sue. For alienation of affection, NC courts look for 3 things. The first being that the plaintiff and his or her spouse were married and that a genuine marital relationship existed between them, and then it goes down to define what that means. Second, that the genuine marital relationship between the plaintiff and his or her spouse was alienated, and then it defines that as the destruction or serious diminution of the love and affection of one person for another. I'll summarize the third part, basically that the third party's wrongful malicious conduct was a controlling or effective cause of that destruction, and that does not have to be the sole cause, even if the marriage already had problems, even if it wasn't perfect, even if they were arguing, that part doesn't kill the claim. It is important to note here that you do not need to prove that sex occurred. That's criminal conversation, a separate tort. Let me know in the comments if you want me to break down that tort. That will have to be its own video. For alienation of affection, the courts and attorneys are crystal clear. Emotional affairs, humiliation, boundary crossing, constant interference, or a third party pulling a spouse away all can establish alienation. Here's the kicker. You can sue more than just a mistress for alienation of affection. You can also sue an in-law who is whispering poison into your spouse's ear every weekend, a friend or a pastor who oversteps and actively encourages the marriage to end, a therapist who violates ethical boundaries, and yes, someone who starts an emotionally intense romantic relationship that sidelines the spouse, even if they haven't slept together. I'm just showing you here how conduct is defined and that there is specific verbiage if a parent's advice is wrongful, then it can be used as alienation. NC courts literally say alienation of affection does not require physical separation or the commission of adultery. It can even be brought against relatives who intentionally interfere. So now let me give you the messy origin story. Like I said before, these are called heart bomb torts, in essence a way to heal the heartbreak that a man suffered in the past. They came from the 18th and 19th centuries, when wives were legally part of a husband's bundle of rights, meaning her services, her society, and yes, her sexual availability, were considered part of his property. Originally, only husbands could sue. You damaged my property by alienating her affection, so you must pay me. Over time, women gained rights, so the tort became gender neutral, but the bones of it are still built on that old property logic. That's why scholars call these torts archaic and misogynistic and out of step with modern marriage. Most states abolished them in the mid-1900s. Only 6 jurisdictions kept them. Per my research, like I said before, I think 1 or 2 other states may have had the tort and recently removed it. But the 6 that I have researched are NC, Hawaii, Mississippi, New Mexico, South Dakota, and Utah. North Carolina said, yeah, we'll keep ours. They tried to kill the tort multiple times and instead just put limits on it back in 2009. And then, in 2017, in Malisic versus Williams, the NC Court of Appeals was asked to declare the whole thing unconstitutional. They basically said, we are not saying these are good laws. We're just saying that they're not unconstitutional on their face. So if you don't like it, call the legislature. So the origin is patriarchal, the modern version is gender neutral, but the skeleton is old and most states have buried theirs. When they say that Akira's verdict is historic, they're talking about money. North Carolina has a history of huge verdicts. Coming in first place is the per-year case from Wake County back in 2011. The ex-wife of a Raleigh trucking company owner was awarded $30 million for alienation of affection and criminal conversation, and this was the largest heart bomb award in NC history. In second place, Shackelford versus Lundquist in 2010, the wife of an NC attorney was awarded $9 million, $5 million in compensatory, and $4 million in punitive. I am curious to know how they met the legal standard for punitive. That is something I might do a deep dive, and if it's interesting and juicy, I'll bring it to you. And in third place, yours truly, Akira Montague versus Brenay Kennard. The jury awarded $1.5 million for alienation, $250,000 for criminal conversation, for a whopping total of $1.75. So this is your top 3. And lastly, what is alienation of affection actually punishing? Because people on the internet keep framing this as, why is a woman allowed to sue another woman for a man cheating? It's not the woman's fault, you should be holding the man accountable. Legally, that's not accurate, and you need to understand the difference. A spouse's infidelity is handled in family court through divorce, support, custody, and property division. Alienation is a separate claim against a third party for their conduct and how it interfered in a marriage. So there are 2 buckets. The first one is the marriage. That's between me and my spouse, and I already handled that through separation and divorce. And then there's bucket 2, which is the third party's behavior. That is where alienation lives, because it asks specific questions. It asks, once you knew I was married, and once you were told to back off, and once the damage was obvious, why did you keep going? Why did you keep crossing boundaries? Why did you keep disrespecting my marriage by having inappropriate conversations? Why did you keep inserting yourself into my family? Why were you mocking me publicly? Why did you keep doing things that you knew would contribute to the end of my marriage? That's the conduct that North Carolina is willing to put a price tag on. Oh, God. Like I've said before, the goal is to understand, not to pretend to be a lawyer up here, so I hope that the information was helpful. Please leave me a comment, show me some love, give me a like, a follow. I greatly appreciate it. And I guess we're ready for round 2. Hope this helps.